Dollar Hegemony as International Lawmaking Power. Internet Salvala. Chinese Journal of International Law, Volume 25, Issue 2, June 2026. This is an open access article distributed under the terms of the Creative Commons Attribution License, which permits unrestricted reuse, distribution, and reproduction in any medium, provided the original work is properly cited. Abstract. The so-called weaponization of the dollar as part of the escalating geopolitical competition has drawn attention to dollar hegemony within the fields of international law, international relations, and political economy alike. This article contributes to discussions about the advantages conferred on the US due to the international role of the dollar, and to emerging debates about international law and political economy by demonstrating that dollar hegemony operates as a form of international law-making power. The international role of the dollar gives the United States exceptional opportunities not enjoyed by other states to influence disproportionately crucial areas of international law, including the law of jurisdiction and the law of sovereign state immunity. This law-making power has been exercised in contradictory ways. On the one hand, the United States has used the privileged role of the dollar to formulate laws that materially benefited financial capital, while also incorporating its logic and ideology. On the other, the United States has used the law-making powers of the dollar in order to pursue short-term, particularistic, geopolitical, and even partisan agendas. Otherwise put, the law-making functions of the dollar have reflected, without being able to resolve, the fundamental tensions that arise out of the use of a national currency as world money, and, in legal terms, the contradictions that inhere in the fact that a globalized political economy remains mediated by domestic legal and political forms. Introduction. 1. In October 2024, representatives of 36 states gathered in Kazan, Russia, for the largest BRICS summit to date. This was partly an exercise in rehabilitating Russia's global standing in the midst of its catastrophic war of aggression against Ukraine. However, more than the immediate geopolitical context was at stake. The BRICS unveiled a plan for a new clearing and payments mechanism. If this plan is successful, it will allow states to trade and invest in their own currencies without having to rely on the US dollar and on US or other Western banking and financial institutions. The success of this initiative is anything but guaranteed. Not least because President Trump has threatened to impose tariffs on states that attempt to move away from the $2. Nevertheless, the ceremonial announcement of the initiative speaks to the commitment of powers such as China, Russia, and Brazil to challenge aspects of dollar hegemony is part of a broader 1. In October 2024, representatives of 36 states gathered in Kazan, Russia, for the largest BRICS summit to date. This was partly an exercise in rehabilitating Russia's global standing in the midst of its catastrophic war of aggression against Ukraine. However, more than the immediate geopolitical context was at stake. The BRICS unveiled a plan for a new clearing and payments mechanism. If this plan is successful, it will allow states to trade and invest in their own currencies without having to rely on the US dollar and on US or other Western banking and financial institutions. The success of this initiative is anything but guaranteed, not least because President Trump has threatened to impose tariffs on states that attempt to move away from the USD. Nevertheless, the ceremonial announcement of the initiative speaks to the commitment of powers such as China, Russia, and Brazil to challenge aspects of dollar hegemony is part of a broader effort to reshape the post-Cold War international order. It would be tempting to attribute international disquiet about the dollar solely to the volatility of the current US administration, or to the bipartisan weaponization of the dollar. Indeed, there is no doubt that rising hostility toward dollar hegemony was accentuated by the dazzling proliferation of financial sanctions against geopolitical competitors of the United States since the 1990s. 2. Although the significance of this immediate context is undeniable, the roots of this discontent run deeper. As global capitalism entered a period of recurring and intersecting crises in 2008, many developing states became increasingly dissatisfied with the macroeconomic privileges afforded to the United States by the fact that its currency is hegemonic on a global scale, thereby enabling the US to export some of the costs of its macroeconomic policies. The precise extent and nature of the economic and geopolitical advantages afforded to the US by the power of its currency are subject to debate, but it is implausible to deny their existence altogether. What remains relatively underexplored within both the legal literature and beyond are the law-making opportunities conferred on the United States on account of the exorbitant privilege that is dollar hegemony. This law-making power of the dollar is the focus of this paper. A critical approach to international law and political economy requires that we understand how the dollar gives the US unparalleled opportunities to shape international law and, in particular, international legal fields that are key to the everyday operation of both global capitalism and statecraft tools, such as sanctions, namely the law of jurisdiction and sovereign immunity. 3. In exploring the international legal dimensions of dollar hegemony, I make two principal arguments. My first argument concerns the process of international lawmaking, and the second concerns its functions. First, I argue that dollar hegemony operates as a form of international lawmaking power. By this, I mean that the international status of the dollar has afforded the US unique opportunities to generate state practice and opinio juris, and, by implication, influence disproportionately the development of international law in important areas such as jurisdiction and sovereign state immunity. This has happened because, since the late 1970s, dollar hegemony has solidified the role of New York as the indisputable center for global finance and has pushed both public and private actors toward ever closer engagements with its banking and financial institutions. This reality has increased the opportunities for US courts and other authorities to claim jurisdiction over disputes surrounding financial assets, and, in so doing, to exert heavy influence on the development of crucial areas of international law, notably the law of jurisdiction and the law of sovereign state immunity. Although both doctrinal and critical international lawyers acknowledge that powerful, often Western, states play a disproportionate role in the formation of customary international law, the specific forms of power that give rise to such law-making powers remain underexplored. My argument departs from existing accounts that posit that the problem lies primarily with international legal scholars and practitioners who privilege the state practice and opinio juris of a handful of Western states when identifying customary international law. Even though these scholarly biases are undeniable and consequential, locating bias solely in the mental process of custom identification ignores the fact that particular forms of material power, in this instance currency power, give some states more opportunities to produce the raw material of custom, state practice and opinio juris, and/or to legitimize their idiosyncratic views through the adoption of relevant treaties. 4. Secondly, I posit that the usages of the dollar's law-making powers by the US have been messy and, at times, directly contradictory. The much-debated weaponization of the dollar against the US's geopolitical foes is the culmination of the contradictions inherent to the fact that a national fiat currency, the USD, operates as world money. Global political economy and international law are both structured around and torn apart by the fact that contemporary capitalism is a global structure that remains mediated by domestic legal and political forms. In attempting to shape international law through the use of the dollar, the US oscillates, on the one hand, between setting out rules that benefit global capital, and in particular global financial capital, and, on the other, shaping the law to promote its own particularistic interests and ideas. 5. This tension between international law as a guarantor of global capitalism and as a promoter of specific national, class or other interests is not a new phenomenon. However, in the immediate post-Cold War period, such contradictions remained manageable due to the material predominance of US state and capital and the hegemonic appeal of neoliberal ideology, the resurgence of geopolitical competition, and, in particular, the organized efforts by China to climb the ladder of global value chains, and the ideological crisis of neoliberalism post-2008, have led to the accentuation of these contradictions. Therefore, the role of the dollar as world money is increasingly in tension with its functions as a tool of US statecraft. This tension is part of a broader one, namely the increasingly unmanageable contradictions that emerge out of the continuing mediation of globalized capitalism by domestic legal and political forms. This tension is central to the contemporary crisis of the international legal order and has been accentuated but not created by the dollar's weaponization and the erratic character of the Trump administration. 6. To substantiate these two arguments, I will proceed in 3 steps. First, I outline a historical materialist approach to the relationship between international law and political economy that combines the primacy of social relations over ideas posited by historical materialism with the indeterminacy critique mounted by legal realists and their inheritors, notably critical legal studies, CLS. In so doing, I propose to overcome certain conceptual problems that emerge out of the constructivist assumptions of scholarship associated with the law and political economy (LPE) movement. Secondly, I put these methodological and theoretical propositions to work by showing that a specific social relationship, currency hierarchy, has operated as a source of law-making power in two crucial areas of public international law: the law of jurisdiction and the law of sovereign state immunity. Finally, I offer an explanation of how these law-making powers have been mobilized to serve contradictory purposes. 2. International law and political economy. 7. In the past decade, Anglophone legal scholarship has witnessed a renewed interest in political economy. The specific focus of this work has been the role of law, including international law, in the constitution of modern political economy. Pushing back against the myth of self-regulating markets, law and political economy (LPE), scholars draw explicitly or implicitly from institutionalism, legal realism, and CLS to argue that the building blocks of modern capitalism, property, contract, the corporation etc., are essentially legal institutions and, therefore, global political economy can only be properly understood and reformed through a close study of law and legal institutions. Some of this scholarship focuses on the role of domestic and international institutions, be it courts, legislatures, or administrative agencies, in reshaping political economy in accordance with the core tenets of neoclassical, in the case of the USA, or neoliberal, in the case of Europe, and internationally, economic thought. Others, notably Pista, have emphasized the role of corporate lawyers as drivers of legal and political economic change for the benefit of their powerful clients, notably financial capital. 8. In this telling, the most important aspect of the relationship between international law and political economy is how the former shapes the latter. The distribution of power and resources is understood as the product of the work of lawyers who operate either in furtherance of particular ideological commitments or in pursuit of the economic interests of their clients and, by extension, their own. This approach offers a thoroughly legal theory of political economy by emphasizing the ability of law to create markets, shape the actions of market actors, and distribute income and power. Insofar as political economy shapes law, the emphasis is on hegemonic political economic theories and ideas, notably neoliberal political economic thought and neoclassical economics, not on the social relations that emerge in the context of finance, commodity production, and circulation. The programmatic conclusion drawn from this view by many LPE scholars is an optimistic conviction that remaking legal common sense can remake the legal infrastructure of capitalism, which in turn will yield concrete material results by ameliorating or even fixing the injustices and unsustainable dimensions of global political economy. In the words of Britton Purdy et al., a legal imaginary of democratic political economy that takes seriously underlying concepts of power, equality, and democracy can inform a wave of legal thought whose critique and policy imagination can amplify and accelerate these movements for structural reform, and, if we are lucky, help remake a polity in more deeply democratic ways. In the realm of international law in particular, the work of Marty Koskenniemi has been pivotal in emphasizing the political subjectivity and ethical positioning of the individual international lawyer as a source of progressive legal and, ultimately, political and economic change. 9. These intellectual traditions pay less attention to how political economy, understood not as economic thought, but as a set of social relations that empower, but also constrain all actors, albeit in different ways, shapes the form and content of law, but also what counts as law in the first place, namely which actors' legal interpretations become influential at different times and places, and under what circumstances law actually succeeds in achieving the political economic goals of those who create and use it. 10. The question of what counts as law or which actors' interpretations of the law matter may appear relatively unimportant in Western, domestic legal settings, where the state has largely succeeded in monopolizing the creation and authoritative interpretation of law. However, as others have shown, they are of utmost significance for international law that remains a largely decentralized legal system without a central law-making body, a hierarchically organized bureaucracy, or a court system with compulsory jurisdiction over all disputes. In the absence of centralized legal authority, states and other actors disagree on basically everything. What subfield S of international law govern a dispute? How to interpret the provisions of a treaty? Whether a rule of customary law governing a specific set of circumstances exists in the first place. 11. If we acknowledge that disagreement and uncertainty are an integral part of law, arguments that posit that, international law is constitutive of global political economy, in the most literal sense, reach their limit. This is because arguments about law's constitutive functions explicitly or implicitly assume that law is stable and determinate enough as to shape social relations according to the preferences of its makers. This view is illusory even in domestic legal contexts, and more so when it comes to international law. To return to Pista's argument, even the most influential corporate or state lawyers do not single-handedly create law. What they do is articulate legal arguments that other actors, be it state or international courts, regulatory authorities, other market participants reject, accept, ignore, or emulate. Pista is correct in identifying that legal arguments on behalf of financial capital have been astoundingly successful over the past decades, as US, foreign, and international courts and other private actors have accepted, emulated, or at least acquiesced to them. This reality does not prove, though, that law creates wealth and power, as Pista posits. Arguably, it points in the opposite direction. It is the unmatched social power of financial capital since the 1970s that has at times persuaded, and in other instances compelled others to accept corporate lawyers' arguments as authoritative. In this telling, political economy becomes important in assessing which legal claims by what actors may gain acceptance by others in particular places and times. In the context of international law, a robust understanding of international political economy can help us grasp not only why the US or other powerful states have been making expansive claims about their own jurisdiction, or offering legal interpretations that depart from textbook understandings of the field, but also when and why other states, international organizations, and businesses accept, or at the very least do not object to these claims. This specific way of bringing together international law and political economy involves asking what social relationships can make claims by different actors appear stable and authoritative enough as to be recognizable as international law. 12. This reframing does not simply reverse the causal relationship between law and political economy by claiming the primacy of the latter. More fundamentally, it demands a reconceptualization of what international law is in the first place, incorporating insights drawn from legal realism and critical legal traditions. It shifts our understanding away from the idea of law as a set of rules that shape political economic outcomes toward the idea of law as an argumentative practice that frames social relationships as rights. In this context, contestation over the meaning of a legal provision, over whether a norm is legally binding, or over which body of law governs a dispute is integral to what law is in the first place, rather than an example of law's ineffectiveness or perversion. 13. Such a shift in our understanding of what international law is in the first place is of import for international law scholars, as well as for political economy scholars interested in the intersection between law and political economy. When it comes to dollar hegemony in particular, recent political economic analyses rely on the idea that eurodollar markets operate outside US jurisdiction, and that this split between currency and jurisdiction is central to the character of the USD is a primarily offshore form of money and, correspondingly, to its relationship to the US state apparatus. This core assumption relies on a rules-centric, reified understanding of international law and law more broadly. Jurisdiction is imagined as something that a state either does or does not possess based on some external rule that prescribes stable, observable limitations to a state's jurisdiction. Moving beyond rule-centrism when studying the relationship between international law and international political economy reveals that jurisdiction is not something that a state does or does not possess. It is a claim that a state makes about the applicability of its laws to a particular set of factual circumstances. If other actors accept or at least acquiesce to these claims, then these jurisdictional claims appear stable, coherent, and legitimate enough that they eventually become perceived as rules. This paper shows that the social power of the dollar both enables the US to make such claims and often compels or incentivizes others to accept these claims as authoritative, or at least acquiesce to them. By this, I do not mean that the USA's claims reflect positive international law in a straightforward manner. This would involve falling back into a conceptualization of law as rules that I have argued against above. The approach that I propose here places contestation over legal form and legal meaning at the core of what international law is in the first place. Third states, as well as other actors, sanctioned states and individuals, global corporations, criminal defendants, law academics, etc., oftentimes contest the efforts of the US to unilaterally shape international law through the social power of the dollar. Moreover, the practice of different branches of US government is not always internally consistent, as different domestic actors use the lawmaking powers of the dollar for different, often contradictory, ends. In other words, although the lawmaking powers conferred by currency power are significant, they are neither unlimited nor uncontested, but rather unfold within a normative and material context that is shaped by conflict. 14. If the value of this argument for political economy lies in moving away from reifying law, then its significance for international legal scholarship lies in constructing a social theory that complements theories of indeterminacy and helps us understand what material and ideological circumstances lead to the temporary stabilization of international legal claims in specific contexts. Challenges to the rules-centric understanding of international law are not novel. Both American and Scandinavian legal realists, as well as their inheritors, notably critical legal studies and critical international lawyers, have argued at length that legal outcomes are at least determined by and at most unrelated to legal texts. This critique of legal indeterminacy has been intellectually and politically generative insofar as it disenchanted legal reasoning and identified the ideological biases, logical fallacies and solipsisms that plague legal scholarship and practice. Centering law's indeterminacy, however, does not in itself explain why and how international law can and does become stabilized enough to appear as rules with determinate content. Otherwise put, moving beyond formalism is an essential first step in identifying the forces that actually shape law, but does not in itself offer a workable theory of how law relates to other social phenomena, nor does it explain how and why particular legal interpretations or legal practices come to predominate in specific historical contexts. Anti-formalism in international law is neither a politics nor a social theory. Rather, anti-formalism is a first step that makes visible the need for a robust social theory that is able to identify the factors that actually lead to law's temporary stabilization. 15. Different strands of anti-formalist legal work approach this task of identifying these factors differently. American legal realists and their empiricist inheritors put their faith in the social sciences, arguing that robust empirical study can reveal the factors that shape the behavior of legal actors. Even though the explanations offered in the course of these empirical studies range from complex explorations of the role of ideology to studies of the legal decision-maker's family life and other personal circumstances. What unites many international legal empiricists is their methodological individualism. In this telling, what stabilizes law is the conscious or unconscious preferences of individual legal actors. The limitations of this approach, especially when it comes to international law, are similar to those identified above in regard to legal constructivism. Individualized approaches to interest or ideology cannot explain by themselves when and why other actors accept or acquiesce to one's legal claims instead of rejecting, questioning, or ignoring them. Rather, an account of structural power is needed so that we can identify the material circumstances and/or ideological convergences that produce the consensus needed to regularize institutional preferences. Treaty interpretations or assertions about the non-existence of custom enough for them to appear as rules. 16. In sharp contrast to the empiricism of legal realists and their inheritors, scholars working within the critical legal studies, CLS, tradition grew increasingly weary of any effort to put forward causal explanations of the law's development. Embracing post-structuralist accounts of law, economy, and society, many CLS scholars cautioned against linking law's development and stabilization to any external factor, including broader political economic structures. In international law, in particular, leading heterodox scholars have prioritized critical redescription and openly doubted the viability and desirability of legal scholarship that focuses on explanation and causal inquiry. This theoretical defeatism of critical anti-formalist work has left heterodox international lawyers with an appreciation that power matters for a field, but without a rigorous theory of what specific forms of power have the potential to stabilize legal arguments in particular historical moments. 17. This paper attempts to move beyond this suspension of explanation as a worthwhile intellectual project by singling out dollar hegemony as a central building block of modern capitalism. In particular, I draw insights from Marxian theories of money and finance to emphasize the tensions that emerge for global political economy in general and for international law, in particular, in light of the fact that a national currency, the USD, has come to operate as world money. I also rely on post-Keynesian approaches that emphasize the hierarchical nature of the international monetary system is a source of significant constraints for semi-peripheral states that the capitalist core and, in particular, the United States do not face. 18. Using a historical materialist framework to analyze the interplay between international law and the US dollar comes with complications. Marx's views on money are often criticized for supposedly downplaying the role of money in capitalist production and/or for being hopelessly out of date due to Marx's assumption that global money had to assume the form of commodity money, such as gold. The former view is unpersuasive. As Copley has argued, money was central to Marx's understanding of capitalism. Marx articulated a fundamentally monetary theory of production and understood money as the social adhesive of a world of privatized production and mass dispossession, which conjures a global competitive logic that Marx terms the law of value. The second objection has more merit to it. It is undeniable that Marx thought that world money, which he thought of as the absolute social materialization of wealth as such, would need to be a denationalized form of money. According to Ivanova, Marx associated this denationalization with gold due to the specificities of his historical context and not due to a deep-seated and theoretically important conviction that only commodity money could operate as world money. Indeed, his emphasis on denationalization as a precondition for the emergence of world money has generative implications for the way that we think about the US dollar and its law-making powers. The fact that this denationalization did not come to pass should alert us to the inherent, as opposed to purely conjunctural, tensions that arise for global capitalism from the fact that a national currency that is not anchored to any commodity has become globally predominant. 19. One final methodological note remains. To construct a comprehensive theory of the law-making powers of the US dollar, one needs to take into account the hybrid, public-private character of money creation in modern capitalist systems. The interplay between private and public authority in the process of money creation is essential for understanding contemporary capitalism and its antagonistic relationship with democratic self-government, as Pista has argued. For the purposes of this article, I have bracketed this question. The centrality of the private sector in the creation of US dollars undeniably restricts the ability of the US state apparatus to mobilize the law-making powers of the USD as it pleases. This limitation, though, does not negate the fact that dollar hegemony confers extensive law-making powers on the US that other states do not enjoy. 3. Dollar hegemony as law-making power. 20. Although dollar hegemony has gathered considerable scholarly and political attention amongst political economists and lawyers alike, a brief explanation of the term is needed. Since the demise of the Bretton Woods system and the adoption of floating exchange rates in the 1970s, a global system of financialized neoliberal capitalism emerged with the US dollar at its core. The dollar operates as a store of value, medium of exchange and unit of account beyond the borders of the United States. Roughly 60% of the world's currency reserves are held in USD, a percentage that has remained stable over the past 15 years. US Treasuries, in particular, have been the cornerstone of international finance, especially in times of crisis and instability, when private and public actors have scrambled to acquire them at all costs. In addition, much of international trade and investment is denominated and settled in USD, even when it does not involve US businesses, products, or services. Crucially, in the context of financialized capitalism, the USD predominates in the financial sector. The USD is on one side of 88% of all foreign currency transactions and makes up approximately 60% of all bank assets and liabilities worldwide. The dollar is both the currency used to denominate and settle transactions involving essential, if destructive, commodities such as oil and the currency in which derivatives used to hedge against price fluctuations in such essential commodities are denominated. This means that calculations about risk in commodity markets and predictions about the future, as well as the transactions based on these calculations, are denominated in USD. So far, dollar hegemony has survived predictions of its imminent demise, not least because of the absence of a viable alternative. The economic rise of China has not been accompanied by a comparable internationalization of the renminbi, which cannot operate as world money for a thoroughly financialized capitalism while the state maintains its control over its financial markets. In addition, the internationalization of the euro was undermined long before the Eurozone crisis by the unwillingness of the European Central Bank to adopt a proactive policy of internationalization, and its unjustified faith that internationalization would be carried out by market actors. Finally, the IMF's special drawing rights, SDRs, do not have the backing of an actor willing and able to act as a market maker, which has confined SDRs to obscurity, despite recurring interest in their potential function as a reserve currency. 21. This lack of a viable alternative has meant that widespread dissatisfaction with the status quo has not brought about a systematic move away from the dollar or an effective challenge to the economic, geopolitical, and legal privileges that flow from the currency power of the US. Here, I am specifically interested in the law-making powers conferred on the US by dollar hegemony. Aspects of this law-making power have already come under scrutiny because they have enabled the so-called weaponization of the dollar, namely the US's pivot to using financial sanctions in order to pressure its allies and punish its geopolitical competitors. This shift has been enabled by the centrality of the US dollar and the US banking and financial system for global capitalism, as even transactions that do not involve US nationals or businesses use USD and are processed and cleared by US-based banks. As the case of Russia demonstrated, even geopolitical competitors of the US are forced to maintain gigantic reserves in the Federal Reserve System and, in turn, expose these assets to freezing or expropriation. 22. Thinking about dollar hegemony as conferring specifically law-making powers on the USA helps us locate with precision what forms of economic power translate into international law-making power. Formalist understandings of international law making insist that the sovereign equality of states means that each state holds equal legal power to co-create international law. This insistence is particularly apt in the case of customary international law, which, according to the formalist view, can only emerge through the material practice and acceptance as law by a sufficiently widespread and representative number of states. This formalist understanding of lawmaking has been criticized for not capturing the realities of international law and politics. For example, Third World approaches to international law, TWAIL, scholars who draw on post-colonial theory, and critical liberals alike have observed that in the process of identifying customary international law or of interpreting treaties, both scholars and, more importantly, courts and tribunals focus disproportionately on the practice and legal views of a handful of Western states and/or of states with enough resources to regularly compile and publicize their legal views and practices, and to do so in English or in French. 23. This heterodox legal view turns our attention from the world of abstract doctrine to the world of international legal practice. In so doing, it correctly identifies the profound Eurocentric biases of this practice. At the same time, this approach is fundamentally idealist, in that it assumes that departures from equal sovereignty in international law making are primarily attributable to the intellectual work of international legal scholars and practitioners. In this telling, all states engage in relevant legal practices and in the formulation of legal opinions, but judges and scholars do not synthesize these elements in a fair, unbiased, or comprehensive way, thereby privileging the practice and legal views of a few Western states, with the US prime amongst them. This argument is correct, but incomplete in significant ways. The other half of the story is that actual material unevenness, including but not limited to currency hierarchy, affects the opportunities available to different states to engage in the legal practices and express the legal opinions that, if accepted by others, create international law in the first place. 24. Thinking of dollar hegemony as a source of law-making power also puts pressure upon the commonly held assumption of political economists that the euro-dollar market lies outside US jurisdiction. Even though sophisticated accounts emphasize that jurisdiction is a legal and not a geographical concept, they nevertheless proceed to think about jurisdiction in terms of being within or outside of it in a definitive way. As I show in more detail below, in the past 15 years, the US has been utilizing the international significance of the dollar to make expansive arguments concerning its jurisdiction concerning sanctions, anti-corruption, and counter-terrorism. This form of choker-point jurisdiction has triggered different reactions by states, international banks, and other businesses. Although states often protest these far-reaching claims, they have also at times cooperated with the US and acquiesced to its arguments. More so, businesses are eager to avoid litigation and, therefore, tend to settle their relevant disputes, thereby acquiescing to the jurisdictional claims of the US. In the process, the US has used mostly successfully the power of the US dollar to refashion its understanding of its own territorial jurisdiction as including transactions with nominal and remote links to its physical territory. In light of these novel arguments and their relative success, the idea that the eurodollar market is outside US jurisdiction becomes harder to maintain. This does not mean that the US is willing to exercise this newly claimed jurisdiction or even able to do so without precipitating a meltdown of the global financial system. It does mean, though, that the limitations that the eurodollar market imposes upon the US are not legal in nature. Jurisdiction and sovereign state immunity. 25. The importance of dollar hegemony for international lawmaking becomes obvious if we focus on two areas of international law: the law of jurisdiction and the law of sovereign state immunity. The law of jurisdiction can be thought of as a concretization of modern ideas and practices of statehood and sovereignty. It allows states to enact, adjudicate, and enforce their legislation within their own territory, and, in theory, restricts the exercise of jurisdiction beyond their borders. This affirmation of the primacy of territorial jurisdiction in international law has been a nominal triumph for the state as a territorially bound political project. But it has always been in tension with the transnational and asymmetrical nature of global capitalism. The disaggregation and dispersion of capitalist production after the 1960s and the transnational nature of finance mean that legal disputes cannot be neatly contained within the borders of a state. Often, economic actors confer jurisdiction over their disputes on particular domestic courts, notably those of London or New York, because they trust that they will be sympathetic to their interests. However, this contractual choice of forum does not exhaust jurisdictional conflicts and uncertainties. States of the capitalist core, and especially the US, have consistently tried to project their laws extraterritorially or to use minimal territorial connections to assert nominal territorial jurisdiction over activities and actors with minimal substantial links to their territory. Dollar hegemony is one crucial factor that enables the United States to do exactly that. The US has utilized the centrality of the dollar for global commerce and finance to claim jurisdiction over an ever-expanding range of transactions. It has done so without claiming jurisdiction over the dollar as such, but by reinterpreting its territorial jurisdiction to include the use of US correspondent accounts, the use of the US interbank payment system, and, most ambitiously, offshore transactions that correlate to payments carried out domestically. 26. In broadening its understanding of territorial jurisdiction to include offshore transactions between non-nationals that rely on US correspondent accounts or use the US interbank payment system. The US exploits the fact that it is theoretically possible, but exceedingly difficult in practice to carry out payments in USD that are not cleared or processed by US institutions. Imagine a scenario in which A wants to pay B $100,000 in the context of a transaction that is lawful in their states of residence and citizenship. A maintains an account with a Chinese bank, banker, and B holds an account with a French bank, bank. Since neither bank holds dollar accounts with the other, they will use the accounts that they do hold with a US bank, bank, to debit $100,000 to the account that bank holds with bank. This is Transaction 1, T1, which is uncontroversially subject to US jurisdiction, since it involved a service carried out in its territory by a US legal person, bank. T1 was a transaction between banker and bank. A and B themselves were neither credited nor debited any amount as a result of this transaction. Then, banker and bank carry out their respective internal booking operations. Banker will credit $100,000 from A's account, B01, and bank will debit B's account by the same amount, B02. B01 and B02 are carried out in China and in France respectively, and they are governed by Chinese and French law, which, as mentioned above, does not in any way prohibit or sanction this transaction between A and B. 27. As Emmenegger and Zuber have explained, the scenario summarized above does not involve a single payment that enters and then exits the US. It is a series of distinct actions that are carried out in the US, China, and France respectively. According to the textbook Understanding of Jurisdiction under International Law, the US has territorial jurisdiction over T1, China over B01, and France over B02. However, US practice over the past 15 years has challenged this traditional understanding of territorial jurisdiction. The US argues that the use of a US correspondent account establishes its jurisdiction over the entirety of the conduct summarized above. Even more ambitiously, the US has argued that it has jurisdiction over offshore payments that do not use a US correspondent account as long as they correlate with payments that were processed in the US. In this scenario, A and B, or, in more practical terms, banker and bank, attempt to put more distance between their transaction and the US banking and clearing system. To do so, they involve a third bank, Banked, known as a satellite bank. Banked makes a USD-denominated payment to B's account. This payment is not processed or cleared by a US institution. Then, Banked uses its own account with Banker to request a dollar-denominated payment that was cleared or processed in the US. This is an inconvenient, expensive, and slow way of carrying out transactions, but it has the apparent advantage of creating two separate transactions and shielding one of them entirely from the territorial jurisdiction of the USA. In their high-profile case against BNP Paribas, US prosecutors argued that even though the payment that was cleared in the US was not as such unlawful under US law, it correlated to payments that violated US sanctions legislation against Sudan. Despite the doubtful international and even domestic lawfulness of the USA's jurisdictional argument, BNP Paribas pled guilty to violating US sanctions legislation and paid a steep fine of almost $9 billion. 28. The practical reach and law-making prowess of these expansive jurisdictional claims are accentuated by the fact that the US has been willing to assert its jurisdiction based on clearing, processing, or correlation regarding a broad range of issues, including sanctions, corruption, counterterrorism, and tax evasion. Correspondent account liability and the correlation theory are indispensable building blocks of the US's usage of secondary sanctions. Even though the overuse of secondary sanctions has triggered concerns about the US's expansive jurisdictional claims over the dollar, the weaponization of currency power by the US has deeper roots. For example, correspondent account liability was an essential component of the country's anti-corruption legislation. It was central to the USA's ability to prosecute foreign nationals in the context of the infamous FIFA bribery scandals. These corrupt acts did not involve, for the most part, football matches in the US, and were not linked to the US in any other way besides the fact that the corrupt football officials' banks used US correspondent accounts to process the relevant payments. Despite the remoteness of the jurisdictional link, not only did the US prosecute multiple FIFA officials and corporate entities, but it also secured the cooperation of Swiss authorities in so doing. Switzerland did not contest the expansive jurisdictional claims by the USA, and, more so, its authorities arrested and extradited to the US one of the indicted officials. These acts of cooperation are crucial in light of the theory of law making that I sketched above. The US making these expansive jurisdictional arguments is not capable of producing law in its own right, according to either formalist or non-formalist theories of international lawmaking. However, when other states and other actors, notably banks and other multinational firms, accept, emulate, or acquiesce to these claims, then the political economic power of the dollar becomes international law-making power. Switzerland's cooperation in the FIFA scandals was not a one-off exception. Switzerland has also shown willingness to accept US jurisdiction over Swiss banks in instances of secondary sanctions and has cooperated with US authorities in the investigation against BNPP, accepting implicitly the applicability of US sanctions legislation to banks operating in its territory. Switzerland's cooperation and acceptance of US jurisdiction is not indicative of all states' attitudes, but it has a disproportionate impact on the real-world operation of the law of jurisdiction, given Switzerland's own centrality for global banking. If Swiss authorities accept US jurisdictional arguments as being reflective of the international law of jurisdiction, then the US positions are reflective of law as far as much of global banking is concerned. 29. More so, private actors who face the consequences attached to these expansive claims are unlikely to contest them in court, even if they have reasonable prospects of success. As Mallard and Son have documented, banks and other businesses are eager to settle cases concerning sanctions or other financial misconduct, even when both the assertion of jurisdiction and the substantive arguments made by the Department of Justice are unlikely to be vindicated in front of US, foreign, or international courts. The threat of exorbitant fines and, crucially, the threat of having one's accounts with US banks shut down and thereby losing access to easily cleared transactions in USD is enough to make litigation an undesirable option for banks and other firms. As a result, even implausible assertions of US jurisdiction have concrete legal, economic, and organizational consequences, as banks are keen to strike deals with aggressive US prosecutors. These deals often require that banks reorganize internally or even hire former US civil servants as sanctions compliance officers in order to avoid litigation. The expansive nature of the arguments summarized above, coupled with the unwillingness of private actors and crucial states such as Switzerland to challenge these claims, means that the potential jurisdictional reach of the USA is in practice almost coextensive with electronic USD-denominated transactions. 30. Importantly, in the area of anti-corruption, the US has used formal international lawmaking to legitimize its idiosyncratic jurisdictional arguments. The OECD Anti-Bribery Convention, which has been ratified by most major economies with the significant exception of China, adopts an explicitly broad approach to territorial jurisdiction, advising states that extensive physical connection to the Bribery Act is not required. Adopted in the late 1990s, the convention was modeled after the FCPA and allowed the US to legitimize and internationalize both its substantive legal preferences that equated corruption with bribery and its bold jurisdictional approach to anti-corruption. Following the adoption of the convention, the Bush administration pursued the implementation of the FCPA with renewed rigor, arguing that they were doing so in furtherance of their international legal obligations. 31. This process of using dollar hegemony to bring about formal international legal change has not unfolded seamlessly across different substantive issues. In areas such as secondary sanctions, USD-enabled jurisdictional claims remain hotly contested, if not by economic actors, at least by some states. Even US allies, such as the EU, have publicly decried its tendency to endlessly expand its jurisdiction, so as to make it almost coextensive with the reach of the US dollar. The adoption of blocking legislation by the EU and China represents an effort to give their discursive objections to these dollar-backed jurisdictional claims legal teeth through a combination of carrots and sticks, offering governmental support and creating a private right of legal recourse for parties affected by secondary sanctions, while also threatening them with punishment in case of compliance. Otherwise put, the law-making powers of the dollar have not resulted in homogeneous legal change across the board. When it comes to anti-corruption, the US has used multilateral treaty making to legitimize its practices, but its claims remain contested in other realms. The international law-making power of the dollar is real and extensive, but not definitive or unlimited. 32. This USD-enabled expansion of US jurisdiction has been further compounded by the fact that the US has been using the political economic power of the dollar to influence another core set of rules of public international law: sovereign state immunity. State immunity exempts foreign states from the jurisdiction of other sovereign authorities in instances where domestic authorities would otherwise have jurisdiction under domestic and international law. Even though all states nominally co-shape the contours of customary international law governing sovereign state immunity, in practice the US and the UK enjoys disproportionate opportunities to shape the scope of state immunity. This is because the hegemonic role of the USD, combined with the instability of the global financial system, means that other states, especially those in the global south, maintain sizable currency reserves, which they use to support the price of their own currencies in times of uncertainty. As it became evident after Russia's full-scale invasion of Ukraine in 2022, even geopolitical competitors of the US maintain such reserves, exposing them to the risk of litigation, executive action, and, in extreme cases, expropriation. Historically, this risk was thought to be minimal given that central bank assets were widely considered to be covered by sovereign state immunity. This relative safety has been gradually eroded due to the introduction of important exceptions to sovereign immunity by the US legislature and their broad interpretation by US courts and international legal scholars. Prime amongst them is the exception to sovereign state immunity when it comes to commercial acts, which dictates that sovereigns can be sued in front of foreign courts if they act as commercial actors. In the words of former US Supreme Court Justice Antonin Scalia, sovereigns do not enjoy immunity in front of other states' courts if they act like market players instead of regulating the market. 33. This exception is not unique to the US. During the 20th century, it represented a broader legal shift amongst Western states that responded to the rise of interventionist capitalism and state socialism by determining that only certain state acts were sovereign, properly so-called, and therefore covered by state immunity. The Commercial Act exception was resisted by the USSR and subsequently Russia, India, and China due to the expansive role that the state played in their national economies. Nevertheless, it has now been adopted globally. Even China, which was the last stronghold of absolute state immunity, recently amended its domestic legislation to that effect. In practice, though, even a successful lawsuit is only of symbolic value if it is not enforceable either due to legal limitations or because the state in question does not have assets in a particular jurisdiction. As a result, claimants prioritize jurisdictions where states hold large and liquid assets, namely New York, and, to a lesser extent, London, in order to bring claims against sovereign states. Per some estimations, US courts decide more cases related to sovereign state immunity than all other states combined. Dollar hegemony incentivizes claimants to pick New York as their preferred forum for bringing a case against a third state, which, in turn, translates into international law-making power for US courts. 34. Much of the relevant US case law in the past 40 years developed as a response to litigation concerning sovereign defaults, particularly in Latin America. As states sought to renegotiate their unmanageable debts, holdout creditors took legal action demanding that they are paid in full and as a matter of priority. In the process of deciding these cases, US courts argued that what matters when determining if the actions of a state, a commercial or sovereign, is not the purpose of this act, but rather its nature, by which they meant the legal means through which it was carried out. Once a foreign government uses a contract, as opposed to legislation or administrative acts, to carry out its business, US courts held that its acts become commercial in nature and are therefore not covered by sovereign state immunity. This is the case even if the purpose of this contract was to holistically manage the sovereign debt of a state. As Potts has argued, these broad readings of the commercial exception did not simply benefit intransigent, predatory creditors, even though they certainly did that as well. They played a broader role in disciplining indebted states in the process of debt restructuring. By leaving the possibility of litigation and even execution against debtor states in distress on the table, US courts' interpretation of the Commercial Acts exception contributed to bringing sovereign states to the negotiating table and to them accepting unfavorable debt restructuring terms. More so, US courts have been likely to grant foreign states immunity in cases alleging human rights abuses or abusive labor practices, and much less likely to do so in cases concerning litigation pertaining to sovereign defaults and debt restructuring. Jamshidi has interpreted this tendency as being part of a broader pattern of US courts' decision making about state immunity that consistently prioritizes the interests of financial capital over those of workers or victims of human rights abuses. Otherwise put, the power of the USD has given the US unique opportunities to shape the law of sovereign state immunity, and the specific way that this power has been exercised is through an interpretation of the Commercial Acts exception that protects the interests of capital, especially financial capital, but not those of labor or other actors. 35. US legislation has introduced an additional exception to sovereign state immunity for states that are considered to be sponsors of terrorism. This piece of legislation dates back to the 1990s and has since exposed billions of foreign central bank assets to litigation and even attachment and execution by victims of terrorism and their families. In particular, assets held by the Central Bank of Afghanistan, Dar Afghanistan Bank, have been subject to prolonged litigation that has created ruptures between the three branches of the US government. The legal risks faced by foreign central banks will be compounded if arguments by US international legal scholars take hold while dollar hegemony persists. Ingrid Brunk has argued in relation to Venezuela and Afghanistan that when the US does not recognize an entity as the government of a state, then the rules of state immunity are not relevant in the first place. As a result, Brunk argues, the US may release a sovereign state's funds to any entity of its choosing, and this action does not engage the rules of sovereign state immunity. This is not a purely hypothetical scenario. In the case of Afghanistan, the US executive released $3.5 billion of frozen assets of Afghanistan's central bank to a legal entity domiciled in Switzerland, the Afghan Fund, that has no plausible claim of being Afghanistan's government. The US executive has not offered an explicit international legal justification of this practice, but it has somewhat ambiguously linked the establishment of the fund to its ongoing non-recognition of the Taliban as the government of Afghanistan. Importantly, besides the Taliban, other states did not protest the establishment of the fund on legal or on other grounds, and the fund has received scant attention from international legal scholars. More so, the Afghan Fund operates under the auspices of the Bank for International Settlements, an idiosyncratic but systemically important international organization that has operated as a locus for the coordination of central banks for decades. Incorporated in Switzerland, the fund is governed by a board that has as one of its members a high-ranking official of the Swiss Federal Department of Foreign Affairs. This overwhelming lack of protestation, coupled with the active cooperation of Switzerland, creates, as with the case of jurisdiction discussed above, law-like effects that may not be captured by formalist theories of international law, making but determine the real-world legal risks that USD-denominated assets of central banks face. 36. All in all, dollar hegemony has endowed the US with law-making powers that other states lack. Even though the usages of these law-making powers have been fragmented and contradictory, they have not been random or directionless. Rather, the US has been able to mobilize these powers both in support of national goals and interests, and in furtherance of long-term, structural interests of financial capital. This directionality of the USA's law-making is further illustrated by the instances in which this newly claimed jurisdiction is not exercised. As noted above, the cumulative effect of US's argument is to bring under its jurisdiction almost the entirety of electronic transactions denominated in USD. Notably, the US has not exercised this jurisdiction, or even signaled that it might ever do so, to regulate global financial markets, notably offshore dollar markets, which have proven to be a systemic risk for global financial stability. The final section of this paper will offer a theorization of the tensions and contradictions that emerge from the way that law-making powers of the dollar have been exercised by the USA. The contradictions of dollar hegemony as law-making power. 37. As discussed above, Marx imagined that world money would need to be thoroughly denationalized and, mistakenly, equated this denationalization with commodity money, such as gold. The lack of denationalization of modern world money brings to the foreground the contradictions that inhere in dollar hegemony, and, in this instance, in the law-making powers of the dollar. On the one hand, these law-making practices put into motion the role of the dollar as world money, which is to say the power of the dollar to subordinate labor, society, and nature to capital's needs and logic. These law-making powers of the dollar were part of the broader role that the US performed as organizer and guarantor of global capitalism between 1945 and the 2010s. As industrial and financial capital became increasingly internationalized, the US state apparatus did not only promote or guarantee the interests of its national capitalist class. Indeed, the very notion of a national capitalist class became increasingly unstable and outdated as global capital became increasingly integrated, as production, circulation, and finance became disaggregated and internationalized. The US protagonized the development of international and transnational laws and institutions that underpin this globalized political economy and became important fora for the negotiation and resolution of conflicts between competing economic interests and for the articulation of ideological justifications for global capitalism. Even when international law-making and institution building did not come to fruition due to irreconcilable disagreements between states or due to domestic political or economic conflicts, as has been the case with sovereign state immunity, the US has mobilized different facets of its material power, including prominently dollar hegemony, to respond to social conflicts across the world in ways that secured the long-term interests of dominant factions of capital, notably financial capital, and the stability of the globalized capitalist order. To return to the example of state immunity, since the 1970s, US courts have subjected an ever-increasing range of foreign sovereign functions to US jurisdiction. By affirming the possibility of litigation and execution, US courts gave creditors of indebted states in the Global South important leverage in the negotiating process of debt restructuring. This resulted not only in the strengthening of the negotiating power of financial capital, but also in giving Global South states an additional reason to accept draconian structural adjustment programs in return for negotiated debt restructuring. In other words, New York courts relied on the power of the US dollar both to support the immediate economic interests of creditors as a class and to contribute to a broader process of neoliberal state transformation in the Global South, especially in Latin America. Similarly, by asserting jurisdiction over disputes concerning expropriations by nationalist and/or left-wing governments in the Global South, US courts have used dollar hegemony to reaffirm the rules of foreign investment protection and to impose heavy costs on governments who question the sanctity of private property and the desirability of transnational investment. When acting in this register, then, the US state apparatus mobilized the power of the dollar to act as a committee for managing the common affairs of global, financial, capital. The international law that the dollar has co-created in the process both reflected and reproduced the dynamics that underpinned global financial capitalism over the past 45 years. 38. In contrast, many aspects of the dollar's law-making powers cannot be understood as juridical expressions of the USA's unique role as former guarantor of the global capitalist order. Often, the law-making powers of the dollar have been a source of global disorder and have accentuated centrifugal tendencies within the global political and economic order. In the absence of genuinely denationalized world money, the dollar remains tied to the particularistic geopolitical interests of the US or to the immediate, short-term demands of sections of US ruling blocs. For example, as empirical work has shown, banks and other businesses are prone to over-complying with sanctions and other far-reaching assertions of US jurisdiction for fear of being cut off from the US banking and financial system and losing access to US dollars. In the process, they trigger a process of deglobalization, as capital ceases or drastically curtails its activities in certain parts of the world due to the possibility of being cut out of the USA banking system and, correspondingly, the US dollar, if they are seen to violate US sanctions. The case of secondary sanctions against Iran is instructive. European firms were keen to participate in the country's neoliberalized economy and integrate Iranian firms and sections of the country's upper and middle classes into their circuits of production and consumption. The draconian nature of US secondary sanctions thwarted this process of Iran's incorporation into a West-dominated political economic order and, also, deepened the state's reliance on oil exports to Russia and China. 39. When operating in this register, the law-making powers of the dollar advance the geopolitical goals and historical grievances of the USA in ways that are directly antagonistic to its fast disintegrating role as guarantor and organizer of the global capitalist order. In this respect, Trump's threats in late 2024 to impose punitive tariffs against those states, notably the BRICS, that abandon the mighty dollar, may be best understood as a crude and unreconstructed reaction to a tension that predates the Trump administration, as particularistic uses of the dollar to further US interests and geopolitical obsessions proliferate. Geopolitical competitors and even allies of the US attempt to deprive the dollar of aspects of its material and law-making power or to even challenge its dominant status altogether. Although the political specificities and stylistic peculiarities of the Trump administration accentuate this crisis, they are not its root causes. Rather, the global capitalist economy has been operating in a world that remains mediated by domestic legal and political forms. In times of ideological hegemony and economic growth, the tensions that emerge out of this coexistence remained manageable and even invisible. However, the economic decline of the USA, the rise of China, and the persistent stagnation of the global economy have rendered this mediation unsustainable. Simply put, the USA is neither willing nor able to operate as a guarantor of global capitalism, and the increasingly weaponized use of its currency is symptomatic of this epochal shift. Conclusion. 40. The international legal order is in turmoil. The origins of this crisis are manifold and impossible to attribute to one single factor. However, an underappreciated source of tension is that the contradictions that inhere in the law-making powers of the dollar have been becoming increasingly unmanageable over the past 15 years. Dollar hegemony has allowed the US to influence international law in ways that formalist legal doctrine cannot capture or theorize. The social power of the dollar gives the US unparalleled opportunities to express legal opinions, engage in legally salient practices, and interpret treaties, thereby exerting disproportionate influence on certain key international legal fields, such as jurisdiction or sovereign state immunity. The ways that the US has used these law-making powers of the dollar are contradictory. Some US assertions of jurisdiction constitute the legal expression of the role of the dollar as world money, thereby reorganizing labor, nature, and society in accordance with the needs of capitalist accumulation in a financialized context. In contrast, other assertions of US jurisdiction have helped destabilize global capitalism by forcing firms to disengage from whole parts of the world and/or by undermining the safety of whole classes of assets in furtherance of geopolitical goals or domestic, partisan agendas. 41. There is no way of knowing if, When and how this contradiction between the dollar as world money and the dollar as the national currency of a state with its own particularistic interests, ideology, and domestic dynamics will be resolved. What becomes apparent in the current conjuncture is that a particular form of material power, namely currency power, underpinned the leading role of the USA not only within the global economic or political order, but also within international law and institutions. The legalization of political economic conflicts often operates as a means of resolving, or at least containing these conflicts by giving them the appearance of technicality and or by adding predictability and stability in their management. In this instance, though, the law that emerged out of the law-making powers of the dollar has been riddled with tensions and contradictions itself. It has often given rise to fierce contestation by other states and to a process of economic deglobalization, as market actors react to the legal risks of interconnectedness by curtailing their international activities. As a result, the current crisis of international law should be understood not exclusively as the contingent outcome of political struggles, notably US electoral politics, but as being inextricably linked to the contradictions that inhere in global political economy itself, and, in particular, in the contradictions that arise out of the existence of a global capitalist economy that remains mediated by national legal and political forms.